Order. On behalf of the committee, can I welcome our panel this morning. We're very grateful to all of you for giving up your valuable time to give evidence to us today. Can I introduce our witnesses? Peter Klepper from Open Europe, Dr. Emily Lydgate from the University of Sussex and a Fellow of the UK Trade Policy Observatory, Sarah Ogilvie from the Trades Union Congress, and George Peretz, QC, from Monkton Chambers. We've got, as always, with this committee, a lot of ground to cover, and therefore, as succinct answers as possible would be very helpful. Please do not feel under obligation, all of you, to answer all of the questions, and some, indeed, will be directed to particular members of the panel because of your expertise. I'm going to kick off. There are those, it's not the view of the House of Commons, there are those who say, well, we should just leave with no agreement at all, a no-deal Brexit or a WTO Brexit as people describe it. What would be the implications of that for a level playing field? What would the EU say in those circumstances about how trade and the provision of services would work if there was no agreement at all? I don't know who wants to have a go at that first. Now, Mr. Peretz, you're leaning forward.
Well, shall I start by sort of looking at the area which I think I've been asked primarily to comment on, which is the area of competition and state aid.
Yeah.
I mean, as a matter of government policy, the position on no deal would be that we would retain domestically state aid rules which aim as far as possible to replicate those of the EU, and we may want to discuss those later. And in terms of just ordinary competition policy, to retain the current prohibitions on anti-competitive conduct that we find both actually in our domestic law as it currently stands, as well as EU law. So from that perspective, from the UK side, there would be no change. On the EU side, there might well be anxiety, notwithstanding what the UK wants to do domestically, about the position on state aid and subsidies. You can appreciate that if you have a very large amount of trade with a very close neighbour, you will be concerned if that neighbour takes a free hand in subsidising industries that are competing with your own domestic industries. So there would be concern, and I think one of the things that the EU would almost certainly do is watch very carefully for any hint of breach of the WTO anti-subsidy rules with a view to imposing countervailing measures, which it has a right to do under WTO rules in response to breaches of the WTO anti-subsidy rules.
And of course, any such dispute, if it did go to the WTO, in the end the WTO could rule on whether our behaviour was within the rules or not?
The disputes can go to the WTO, but of course in this field there's a lot of room for self-help measures. The EU can simply impose retaliatory, or what effectively are retaliatory tariffs called countervailing measures, which has a right to do under WTO rules, and it would almost certainly do that if it felt that subsidies were being granted in a way that contravened WTO rules.
And if it did go to the WTO, is this the dispute resolution body?
That would be.
And what sanctions does it have on a WTO member state?
Well, the WTO can rule that there has been an anti-competitive subsidy in breach of its rules. A challenge might be brought by the UK to the EU's countervailing measures, saying you've got no right to do this because, in fact, we haven't been subsidising. And there would then be a dispute, and the UK would be bound by the ruling of the WTO, and the UK has always said that it would respect its international obligations, and if there's a WTO dispute, a panel that finds that there's been an unlawful subsidy, then presumably the UK would cease that subsidy.
And what in practice then is the difference between being bound by a ruling of the WTO dispute resolution body and being bound by a ruling of the European Court of Justice?
Well, in terms of when it comes to enforcement, there's a lot of difference between the state aid rules, for example, they're currently set up, or as they would be set up under, say, the backstop agreement and WTO. I mean, primarily, the substantive rules are not that much different, although WTO rules don't apply in the area of services. One has to remember that. But the enforcement is very different. WTO enforcement is state to state, so that there's room for diplomacy to play its part in decisions as to whether to enforce or not enforce. The state aid rules are part of domestic law and produce rights for third parties. So it is, and are enforceable by the national courts, which WTO rules are not. So that at the moment, if, and I'm involved in litigation where this is happening, if you're a complainant who thinks that a state aid measure has been granted by some public authority and hasn't been appropriately cleared by the Commission, you can take that issue to court, get a ruling, and ask for an injunction stopping the aid or a decision quashing the decision in question on public law grounds and so on. So you've got something which is domestically enforceable. And while we're a member of the EU, that is something we have to do as a matter of EU law. I mean, I have to say, I think because the government's own policy is that we continue to operate the state aid rules, I suspect in practice on a no deal, assuming that that commitment turned out reflected in the current no deal statutory instrument, continue to be maintained, it's actually in practice very unlikely that there would be any WTO dispute, because if we have an effective domestic state aid structure, we're simply not going to be in a position where there are, or very unlikely to be in a position where there are WTO issues. It would be more an issue if the government changed its policy or a different government came along with a different policy.
That's very helpful. Does anyone else want to? Yes. Dr. Luque.
Another element of no-deal preparations that I think is relevant to the level playing field issue is that the UK government has produced a vast amount of legislation, over 10,000 pages, in the form of statutory instruments, which essentially convert EU-derived legislation into the UK law books. The government's position on this is that these are simply technical changes, that they don't embark upon major policy changes. But I think we need to keep in mind that they are actually replicating they're replicating what the EU is doing. In so doing, they're creating new competencies and new procedures for the UK government. And this is something that disproportionately impacts environmental law. So DEFRA produced the greatest number of these of any department, 116, I think it is. So we have a piece of research coming out today, actually, which looks into, for example, pesticides, secondary legislation, and we find that essentially it is creating new procedures for the UK government, for example, to approve new active substances, which are the active ingredients of pesticides, which was previously done at the EU level. It also sets maximum residue levels for food, again done at the EU level previously. So there is quite a sort of dramatic overhaul of the EU legislative process, which has already been put into place to come into effect when we exit, whether through no deal or a deal.
Okay. Now, the Northern Ireland Protocol, the backstop, contains provisions relating to a level playing field. Looking at those, are they the minimum that you think the EU will expect in any circumstances, in any agreement? So if the future partnership negotiations take place and agreement is reached, do you think the level playing field provisions will look basically the same as what's in the Northern Ireland backstop anyway? Yes, Mr. Clever.
Thank you. Well, level playing field arrangement is basically a condition in return for market access. Mm-hmm. So under backstop status, the United Kingdom only enjoys tariff-free access. It does not enjoy market access as provided currently by the EU, so that's something that still needs to be negotiated. As a result, the conditions that the EU has required in return for market access are, in the EU's mind, lower than they will be in case the UK would enjoy more market access as a third country. So whether the EU will secure that or not, it will definitely ask for higher level playing field conditions, for more conditions. For example, at the moment, if you look at the level playing field arrangements in the backstop, there's a commitment from the UK side to follow the non-regression principle when it comes to environmental and labour regulation. but no arbitration arrangement is foreseen. So if the EU says, hey, you are not, you are actually regressing, and that's violating, and that's in violation of the arrangement, of the backstop arrangement, then no arbitration procedure can follow. So I don't want to go into detail unless you ask me, but many of the arrangements in the backstop are actually not all that strong for the EU at the moment. So to answer your question, I think it's quite likely that if the United Kingdom asks for more access, that they will, that the answer will be from the EU side, sure, but there have to be more stringent conditions in return.
Now, just
it may be helpful for me to comment, because I think, in a sense, the glaring exception to what Peter has just rightly said about the slightly not entirely the slightly weakly enforceable nature of some of the backstop provisions is the sort of very glaring exception to the state aid provisions, where the backstop provisions tie the UK quite tightly down. There's, to put it bluntly, quite a lot in the backstop provisions about state aid. The provisions, for those who are not familiar with them, what the backstop provisions about state aid actually do is they allow, for a start, there's a separate regime for Northern Ireland. Northern Ireland effectively remains in the current EU state aid regime supervised by the Commission. So the Commission will still be looking at UK measures insofar as they affect Northern Ireland. In relation to Great Britain, there will be an independent state aid regulator, the Competition and Markets Authority, and that will have to apply the full gamut of EU state aid policy, including state aid policy and law as it develops. So it'll have to follow along. It will have to send all of its decisions to the European Commission, which will have the right to comment on them, and the CMA will then have to treat the Commission's views, quotes, with utmost respect, close quotes, which probably means that it has to have really, really good reasons for not following what the Commission says. So you've got quite a tightly specified, quite a tightly controlled regime. Now, the reason for that, in my view, is that that's because of the customs union provisions. And because, as I explained earlier, one of the things you can do in response to a close neighbour with whom you have a lot of trade inappropriately subsidising the industries that compete with you is you can impose retaliatory tariffs, countervailing measures. You can't, as a matter of practice, certainly do that if you're in a customs union with no trade barriers and no checks. And if that's what one's asking the EU to do, it's inevitable the EU will say, well, since we're effectively disarming, you're asking us not to throw away this weapon that we would have. We therefore expect you in return to sign very, very clear, firm commitments that you are going to stick by the state aid rules. So those provisions are very tight. As a matter of general policy, the EU, in its relationships with countries like the Ukraine and Turkey, where there's a sort of customs union, has also agreed state aid provisions which require those countries to have a domestic state aid law regime. So I think one can say that any deep relationship with the EU, along the lines, I think, advocated by any member of the House, including sort of Canada Plus, a condition of that will be signing up for the state aid rules. But the extent to which the EU keeps the sort of very, very close supervision of the UK's implementation of those rules might be somewhat less if you're not in a customs union relationship or a full customs union relationship. We would have that would be the negotiation.
Dr. Lydgate.
Well, I was going to make a clarification about the environmental commitments, but perhaps that might come out a bit later. I think the Commission has been clear that it will seek enforceable level playing field commitments in any model of trade agreement going forward, even a sort of more basic, you might call it Canada-style agreement. And of course, the political declaration on the future relationship does also say that it will build on the level playing field commitments. So I think that it is useful to view these as a sort of minimum standard going forward.
So Is it fair to say that in just about any circumstances, the EU is going to require of the United Kingdom level playing field commitments in return for any kind of deal? Is that your
Yes.
assessment
Yes.
of what the position will be?
Yeah.
Fine. Okay, that is extremely helpful. Sammy Wilson.
Just in relation to Northern Ireland and the rest of the United Kingdom, is it the case that in Northern Ireland's example that the level playing field will extend to measures which will not be required in the rest of the United Kingdom, and that the means of enforcing the level playing field in Northern Ireland are different insofar as the European Court of Justice will make the final decision, whereas in the rest of the United Kingdom it will be the Competition Commission or some other independent authority, and the only requirement for the government is to notify the Commission when it intends to make any changes which may affect the level playing field provisions.
I mean, that is right, certainly in the state aid field, that in Northern Ireland will effectively remain in the EU state aid regime in terms of enforcement, so that the Commission will retain its powers and the European Court of Justice will, because that's the body you appeal to against a Commission decision, will retain its role. And in relation to Great Britain, enforcement, as you say, will be domestic of the Competition and Markets Authority, subject to control by the UK courts. It's important, though, just to be aware, though, that, as I've explained, the CMA in Great Britain will, in practice, need to follow very closely what Commission policy is, and indeed the Commission is likely to play a major role because of its right to effectively sort of supervise or to cast a close eye over CMA decisions. It will have a considerable input into those decisions. It's also likely, as a matter of practice, that UK courts, in interpreting the state aid law rules, will remain very close to what the European Court of Justice line is on questions of state aid law. In practice, I think that it's going to be very difficult to persuade the UK courts under the backstop regime to do anything, to interpret the law any differently from the way in which the ECJ does it. So in practice, the rules may be the same, although the characters enforcing them may be somewhat different.
So when the protocol in Annex 4 of the Withdrawal Agreement talks about consulting with the European Commission on all of the draft decisions which the government intends to take, it really goes beyond consultation, because the Commission can prevent changes being made in UK law on the wide range of issues if it decides that it militates against the level playing field.
Well, in state aid, the agreement will require the UK to operate a domestic state aid law regime. So the UK will have to do that, and that regime has to track EU law. That's also a requirement. When it comes to individual decisions, because state aid law involves a lot of judgment calls about sometimes sort of legal questions, whether something is made at all can be legally quite difficult. And then, as a matter of sort of legal policy, in what circumstances and on what reasons do you clear a state aid on general public interest grounds? On that sort of decision making, which is administrative, what the backstop requires is that the CMA, which will be the decision maker, is required, as you say, to consult, but also to treat the response back from the Commission with utmost respect. That's the phrase used. Now, lawyers can probably have a bit of fun arguing about precisely what that means, but I would interpret it as meaning you follow the opinion unless you have a really, really good reason not to. I think that's probably accurate enough.
When Michel Barnier then talked about any partnership having to be governed by specific obligations which guarantee a level playing field, and he includes taxation there.
It does, very much so.
I mean, does that mean that if not in the withdrawal agreement, later on in the future relationship, we could specifically find that there are obligations which we have and which we have to guarantee in relation to, say, for example, corporation tax or VAT rates? And how much freedom does that then give a Chancellor when it comes to fiscal policy?
Well, it would it would be the same position as there is now. And it's important to remember, I mean, as a state aid can be given in the form of a tax break, and and in a sense, when you think about it, that must be right. There's no point in having a rule that stops government just writing a cheque to a company if you allow the government simply to give a company a tax break when it wants to. It's effectively the same thing. So it's been well established since the European Economic Community was established that state aid rules had a tax implication. State aid law does not stop a general reduction in the tax rate. So if, say, Northern Ireland had the power to and wanted to reduce general corporation tax rate levels, there's no difficulty with that. Ireland, after all, has a lower corporation tax rate, and it's free to do so within the state aid rules. What the state aid rules deal with is effectively sort of discrimination, if you think of it as tax breaks, you have it roughly right. It is exceptions from a general tax rule in favour of particular companies or particular industries, so that an exemption from corporation tax for the widget-making sector would be a state aid because it's effectively giving the widget-making industry a better treatment. It's effectively the same as just writing them a cheque, effectively. So in that sense, it does constrain what chancellors can do. It constrains them in the particular, but not in the general. Of course, at the margins, you can have arguments about whether a measure is general or not, and that keeps people like me happily employed.
Would it constrain, for example, specific regions? So, for example, if Northern Ireland wished to reduce the level of our passenger duty, the corporation tax, VAT, or whatever applies to a specific region of the United Kingdom, would that be regarded as state aid rule, as breaching state aid?
There is clear case law on this. Yes, a regional government or a national government, whatever you want to call it, Northern Ireland, can have a lower rate for its area, provided that it's not immediately refunded, as it were, by a cheque from central government. So if it's a matter of its own, when making its own budget, the Northern Ireland Assembly says we're going to have a bit less revenue and we want to have a lower APD rate or a lower corporation tax rate, that's absolutely fine. Yes, that's a case called the Azores case, decided about 10 years ago, I think, which makes that absolutely clear. Yeah.
Okay. Howell Williams.
Thank you. Can I ask you, Mr. President, specifically about differential rates of VAT, as decided, if you recall, in the ECOFIN meeting in, I think, 2008, where you have differential rates for labour-intensive industries, which some countries have applied to their tourism industry, but the UK has decided not to do so. So what would be the fate of that sort of provision? Is that state aid, or is it aid to a specific sector? I'm concerned that in the future that tourism will have the full rate of VAT in the UK, but other European countries will not.
Yes, in principle, you can give a state aid through an indirect tax, VAT, so that if the UK decides to lower VAT for a particular sector, that can be a state aid. In practice, while we've been a member state of the EU, that hasn't mattered that much, partly because the VAT directive itself sets out the permitted exceptions, or sometimes, in some cases, required exemptions from VAT. And as long as you're sticking within the directive, there's no question of there being state aid, or simply applying EU law. And on occasions where there is member state discretion, there's a separate area of EU law applicable to VAT called the principle of fiscal neutrality that effectively constrains what any member state can do in terms of discriminating between industries in its VAT structure. And in effect, state aid has taken a back seat. It potentially applies, but VAT law itself constrains member states to such an extent that the problems tend to be dealt with in that framework. Outside the EU, of course, quite probably there won't be much constraint on what the EU, in terms of sort of specific VAT commitments on what the UK can do. So state aid may have a bit more to say, but there's not much case law in that particular area.
Does the relationship with Turkey and the Ukraine shed any light on the potential status that the UK would have in the future after after leaving.
Sorry,
Does the relationship with Turkey and the Ukraine
yeah.
shed any light on this?
Not as far as I'm aware. I mean, I have to say I haven't followed. I simply don't know whether a Turkish state aid case involving indirect tax. They have their own domestic regime, about which I'm afraid I know very little, but I know it's there, and the Commission keeps an eye on it.
Thank you.
Jeremy Lefroy.
Thank you very much, Chair. Just continuing on state aid, maybe to everybody, but particularly, firstly, to Mr. Peretz. What do you believe are the main challenges for the UK in setting up our own state aid authority?
I think, well, there's a sort of immediate challenge of finding enough people properly to staff and run the authority. State aid is a little bit of a niche discipline even within the field of competition law, so a lot of competition lawyers steer away from state aid. So it has its own volumes of case law, legal practice, and sort of knowing a way around the system that takes a little while to master. The CMA has by and large done that. They've recruited a team that's up and ready to go. I think the more fundamental challenge is finding a role for the independent authority within the UK constitutional system. I mean, state aid rules applied by the Commission, when it applies state aid rules, of course, is an international body. It's not answerable to any particular government. Whereas the CMA is constitutionally part of the Crown, part of the UK government. Though its current area of activity in sort of classic competition law does on occasion cause it to sort of come up against central or government agencies, because government agencies can in certain circumstances breach the competition rules if they're sort of trading. That's only a minor feature of the overall competition rules, whereas in state aid, dealing with government is right at the heart of what it's about. And maintaining political independence in those circumstances is obviously much more difficult. There's much more tension between the government and a regulator than there is in ordinary competition policy. That will be a major challenge for the CMA. There are also going to be particular challenges when it comes to the devolved governments, because, I mean, as I wrote in an article that some of you may have written, it's and as a point that Mr. Wilson brought up, if a devolved government passes legislation using its tax powers that involves a state aid, to take a crude example, if a devolved government decides it wants to exempt the widget industry in its nation from a corporation tax, fairly straightforward state aid, and the Competition and Markets Authority then, under the current domestic rules are set out in the no-deal state aid measure, would have power to say that piece of legislation was invalid as a matter of state aid law. That's slightly startling if you're thinking about legislation passed by a devolved parliament. The backstop provisions would require the CMA as well, again a point I've made, to have power to overrule even an Act of Parliament which involves state aid, Act of the Westminster Parliament. That's because the backstop requires the CMA to have the powers that the Commission has, and the Commission currently has that power. It's never used it because Parliament's been wise enough not to pass legislation that directly, well, as I say, never used it. There's a recent CFC, the Recent Control of Foreign Companies decision, effectively says that regime is contrary to the state aid rules, and that will have to be replaced. So you can get tax problems with Westminster Parliament. But under the national regime, you've then got to work out what is the CMA's relationship with central government. And the politics of this are difficult, and the CMA is well aware, I think, of the difficulties of this.
Thank you very much. And you've answered my second question, which was going to be about the interaction with devolved governments, which other colleagues might want to pursue. My final question is really, what are the constraints on the European Union in its own state aid policies? I'm thinking of, we sort of assume that the European Union itself will have the most beneficent state aid policies, the purest. but actually they might decide in their own way, for their own reasons, to go in a very different direction, much more state aid if they feel that certain industries are being, as they see it, under threat from around the world, particularly perhaps from Asia and other places. What constraints do they have in terms of rolling back on the state aid provisions that they're currently saying are ones that we should also follow? So might we ourselves find ourselves in a position where our rules on state aid are much stricter than those of the EU? Would we then have come back and be able to go to the EU and say, I'm sorry, but what you're doing in terms of state aid is not acceptable because our standards are much higher?
Yes, I mean, a couple of points. First of all, it's I think fair to say that the United Kingdom, under all governments since its membership, has tended to be on the sort of, for want of a better word, the liberal side of the argument, more sceptical of justifications for subsidy, and has tended in general terms to push the EU in that direction. The UK has certainly always been very keen that the EU has very strong enforcement powers and uses them. Obviously, the UK is delighted when the Commission uses those powers in relation to the other member states, but has genuinely tended to accept that it's fair enough when, on those occasions where the powers have been used against the United Kingdom. Without the UK there is certainly probably an increased chance that policy might move in a sort of a bit more of a pro-subsidy direction. There are quite a lot of there are constraints on that, but within just the framework of the treaty. The treaty defines what a state aid is, and that's effectively unchangeable, except through judicial development of the law. There's the main area for policy change is in the area of deciding on what grounds you rule an aid to be compatible with the common market, i.e. clear it. And there is scope for policy development in that area, which might move in a less liberal direction.
So would the UK's remedy be via the WTO ultimately under such circumstances?
I mean, there might come a point at which we felt that a subsidy that had been cleared, even though it had been cleared under the EU state aid rules, nonetheless violated the WTO. So we'd always have the freedom to do that. But I mean, it's certainly right that EU policy can move as indeed UK policy could. And one of the challenges, and if there's a challenge the EU currently faces in its relationship with countries like the Ukraine and Turkey, is how to keep the regimes broadly marching in step. When quite a lot of it is about policy, quite a lot of the day-to-day decision-making is about policy as much as it is about law.
Thank you, Chair.
All right. Now, Richard, did you have a very quick question on this specific issue before I bring John Whittingdale in?
Thank you very much. Yes, and sorry to stick just with one of our witnesses for this, but you seem to be the state aid man, George Parrott. Just very briefly, I mean, it has been mooted that the leader of the Labour Party's interest in not being in the EU, or part of his interest, is in order to be able to use state aid much more flexibly. So can you just sort of clarify for us where state aid rules kick in? So, for example, if a government of the UK wanted to renationalise utility companies or train companies, would that come under the EU's level of interest, or because they're purely domestic-only operations, it would not do so, whereas the nationalisation, for example, of an airline operating in the EU would do so? Can you just give us an idea of what the level of interest is?
Well, I mean, nationalisation of an industry as such isn't a state aid matter at all. The only situation in which state aid would arise in a nationalisation would be if the government paid too much for the assets it was acquiring and therefore conferred aid on the sellers of the business. I suspect that's not Labour Party policy. So it's a slightly academic point. So nationalisation, there's a sort of debate going on as to the extent to which other provisions of EU law, rather than the state aid rules, may constrain nationalisation in practice. The problem tends not to be that there's any objection to state ownership of industry. problem tends to be that there are various sectors, such as post and rail and so on, where there's a requirement to permit competition. So you can't have a state-owned monopoly.
And just very briefly on energy, for example, subsidies for renewable energy, onshore wind, solar, marine, whatever. And what about also pumping taxpayer funds into resurrecting closed coal mines, for example? Do any of those things cross state aid?
Oh, well, those would all, in principle, involve state aid.
Regardless of whether we were actually in the EU or not, because they would have an interest in a neighbour's activity.
If we had agreed to implement anything like the state aid rules, then those sorts of things would be covered by that. Yes, I mean it's fair to say though that a lot of measures in the environmental and energy sector are covered in any event by what are called block exemptions, which are categories of aid that you don't even have to notify to the Commission for clearance, are sort of automatically cleared. In the area of environmental policy and energy policy, there are a lot of those, and they are important. In fact, the vast majority of aid that's given by member states is covered by those exemptions if it goes anywhere near the Commission. But doubtless we would apply. I would expect without any complaint from the European Commission, we would apply our own exemptions regime, which the Commission could hardly complain about if it more or less mirrored the EU regime.
Thank you.
Okay, thank you, John Whittingdale.
Thank you. Can I ask you a fairly broad question, but just to clarify in our minds in relation to level playing field requirements? To what extent does the relationship between the EU and a third country, and there are a variety of different types of such relationship, impose requirements for level playing field provisions which go beyond the WTO sort of blanket requirements? Is it possible for you to give just a brief sort of description in relation to, for instance, EEA members, association agreement members, Switzerland, and then FTAs like Canada?
Now, who would like to take? Mr. Clapp.
So if you look at the lightest requirements, those are to be found in the trade deals that the EU has concluded with Canada and Japan. So there's a requirement to have something like international standards, but there's not really proper enforcement. The methods used are to have consultations mechanisms. If you go further than that, you end in the relationship between Switzerland and the EU. Now, the initial idea back in the 80s was coming from the Commission President, Jacques Delors. So he wanted to have a uniform arrangement for third countries. And the principle is very simple. He wanted to have the principle that they would get 100% market access in return for full rule takership. So that is eventually the arrangement that Norway, Iceland and Liechtenstein have. But that arrangement was rejected in a referendum very narrowly in 92 by the Swiss. What happened afterwards was that they agreed what you can, I think, describe a pick and choose arrangement, whereby the Swiss would selectively align with EU regulation in return for only selected market access. For example, in services, the Swiss only have limited market access. Now, in many cases, the Swiss do take over EU rules, but they do take them over in a voluntary manner. The enforcement mechanisms are relatively weak. So the two main concerns that the EU currently has with the Swiss arrangement, which is one of the reasons why they are absolutely not keen to grant it to the UK, is first of all, it's not dynamic, meaning that the Swiss are not obliged to take over updates of regulation. Secondly, also that the European Court of Justice does not have a role or some kind of a court like the EFTA court, which is not like the ECJ, a bit more lenient, but that you don't have a proper court system. So if there's a dispute, it has to be sorted out on the political level. And at the moment, the Swiss government had sort of committed to agree to some kind of a arbitration system, very similar to the one that Theresa May agreed in November. And then secondly, the Swiss government had also more or less committed to the dynamic aspect, to take over updates of EU regulations. But within the Swiss political system, until today, it appears not possible to have that agreed. Just before Christmas, the EU has issued an ultimatum. So I think it's quite interesting to follow that from the United Kingdom, because there's a lot of similarities. So the Swiss, in terms of level playing fields requirements, in terms of conditions in return for market access, are somewhere between Norway and Canada.
And can I ask you a second sort of general question of the same kind, which is looking at all of those different levels of obligation to maintain level playing field. In each case, to what extent has that constrained the third country from reaching trade agreements with other countries?
Well, sure, you can answer that if you want. Yeah.
So I think that the key issue, well, there's a couple of key issues. One of them is to what extent the trade agreement requires substantive alignment with EU regulations. And the second one is to what extent it covers product-related regulations. So if we take the association agreement model, there's a broad alignment with EU regulation, which encompasses not only sort of broader environmental regulation, but also product standards. And that would certainly constrain, say, Ukraine from changing those standards to match with another trade partner. If we look at a more basic example, for example, Canada, it doesn't just include an agreement to uphold international standards. It also includes a non-regression commitment to uphold domestic environmental enforcement and not to lower environmental standards in order to benefit trade and investment. So that is in there, but there's no specific alignment with regulations. It's simply a sort of, it goes beyond a best endeavors clause, because it does involve sort of convening various groups to discuss and monitor this, but it's not enforceable through the main dispute settlement mechanism of the agreement. And I think it's probably more useful to look at this in the context of what the backstop how the backstop would constrain us, because it's quite a unique model. Should I elaborate on that? Would that be of interest?
I'm sure some of my colleagues, before you do, I'm sort of particularly interested in if we can never get out of the backstop, and we are therefore able to have a sort of Canada plus, let us say, arrangement with the EU. To what extent, almost whichever type of relationship do we have, or indeed any third country has with the EU, do we have to translate the requirements which we have accepted as part of our agreement with the EU into any trade agreement which we then reach with a third country? So if we say to the EU, yes, we will maintain these standards, do we then, in order to protect the EU from goods coming in through an open door of our own trade agreement, do we have to include those same provisions in the trade agreement we might sign with any other country?
So you're speaking about in the backstop?
No, I'm not. I'm still speaking post-backstop, if ever such a situation exists.
Well, again, I think this really gets back to the issue of product versus non-product related alignment. So it depends on what we agree with the EU. So if we agree with the EU that we're going to harmonize our SPS regulation with the EU, then that would very clearly limit our ability to diverge in those areas. If we develop a broader environmental cooperation agreement that involves air quality, for example, then that wouldn't impose that constraint.
What I'm getting at, I suppose, and I think you've essentially suggested this is the case, that in almost whatever limitations we accept as part of an arrangement, a future trading arrangement with the EU, we are going to have to put those same arrangements into whatever relationship we have with other countries with whom we reach a free trade agreement. Is that essentially correct?
I mean, I think it rather depends what area you're talking about. I mean, in the area of, which I've been talking about, state aid and competition, I mean, there's simply no reason why there should be read across at all. I mean, these are matters about regulating our own domestic.
No, I wasn't
conduct.
thinking so much
if you're
state
talking
aid.
about
I was talking about
workers' rights or environmental or, well, I mean, a commitment to the EU to maintain workers' rights within the United Kingdom, I wouldn't see that would impose any obligation on us at all to specify minimum levels of workers' rights protection in, say, an agreement with the United States. I suspect a requirement that might cause the United States some difficulty. But I just don't see why it would do that. Environment, this is Emily's area rather than mine, because that's an area where she says you can get into product-specific regulation. And if we had agreed with the EU to take, an example from the field of agriculture, that meat would not be sold in the EU that contained unacceptable levels of hormone, then that, as part of an agreement on SPS measures, that plainly does constrain potentially the type of arrangement. But you've got to look at exactly what level playing field measure you're talking about. And there are a lot of level playing field commitments in the areas that we're all talking about that just would have no impact at all on what we could agree with third countries.
Okay. Right, thank you very much indeed. Pat McFadden.
Thank you. I'd like to ask some similar questions, but about labour law, and perhaps to bring in, for the first time, Sarah. Can you begin, Sarah, by telling us what our obligations on labour law are under the backstop provisions?
So, what the backstop says is that during the lifetime of the backstop, the UK won't reduce the level of employment standards that exist.
Won't reduce? Is that the
yeah.
phrase you used? Yeah.
So, in terms of what we have at the moment, it's essentially a non-regression clause. So, whatever employment protection is in place at the end of the transition agreement, that is what will then go in place throughout the backstop. What it doesn't do is it doesn't commit to keep pace with developments that take place in the EU after we have left the arrangement. And what it doesn't do is set out an international enforcement mechanism. So at the moment, if you want to enforce your employment rights, you can go to courts in the UK, you can go to the Court of Justice of the European Union. Infringement actions can be brought by the Commission against member states. All of these things have happened to the UK, and we won't have the benefit of any of that stuff, and instead you'll be relying on the domestic legal system to enforce your rights. So actually, even though there's not going to be a regression of your rights, your enforcement of them will be a bit tougher. It won't come necessarily with the interpretation of the Court of Justice of the European Union. So actually, there is a bit of a loss all round, I would say.
Okay, let me tease out some of that if I can. First of all, on this business about non-regression or dynamic, let's take an example. If, for example, the EU were to agree a new posted workers directive, which developed rights in that area, quite an active area of discussion, under the backstop provisions, there is no compulsion on the UK to amend its law in line with whatever that new directive would be. Is that?
Yes, that's completely right. And in the specific example of posted workers, we know that when it was being discussed at the level of the Council, the UK abstained. When it was discussed at the European Parliament, Conservative MPs abstained on those votes. So you can kind of read into that under the current government, we'd be likely not to adopt those kind of progressive measures, yes.
Okay. In these cross-party talks that are taking place, this issue of dynamic alignment of rights is quite live. I'm a Labour MP, and my party is asking for dynamic alignment. So to take that posted workers directive example, as I understand it, what we are asking for is a commitment from the government to align with such future directives. But there's a question then of enforcement, which you raised. And enforcement at the moment is fairly regularly through the ECJ. It's not a rare thing for employment cases and employment law cases to be held before the ECJ. So could you tell us a little bit more about, even if there was a political agreement on dynamic alignment in the future, what would be the recourse to enforcement mechanisms for a worker seeking to enforce those rights?
I mean, this is where we come to a bit of the problem, and one of the TUC's concerns throughout this whole process is, basically what we want to do is look at the kind of protections that working people have right now and make sure that whatever happens, whichever deal is adopted, there's absolutely no reduction in those protections. And it's not just the laws that are written down that are the protections, it's how they're enforced. A very particular feature of the Court of Justice of the European Union is that in the area of labour rights and labour standards, it's historically adopted a very broad interpretation. It's tried to make sure that as many people can benefit from a right as possible. It's managed to keep laws up to date and kind of help the law make sense a little bit. Equality, discrimination law can be quite complicated, and the court has really helped us to work through those issues. And we want to hold on to all of that under whatever future deal we have. Now, we would really, really welcome the government saying that it would commit to dynamic alignment, but for as long as we sit outside the CJEU or some other independent judicial system, there will certainly be a loss of enforcement rights for workers here in the UK. If I'm completely honest, really anything short of an international agreement that we will have dynamic alignment and that there will be some sort of additional arbitration process that individuals can access themselves, because that's another thing that they can do to the Court of Justice, then that would be a loss for working people here in the UK, and we would find it hard to back up MPs who wanted to vote for that sort of deal.
I think you've raised a very important point there, because what you're saying to us, correct me if I get this wrong, I don't want to put words in your mouth, what you seem to be saying is that dynamic alignment, for that phrase to be meaningful, it's not just a question of the legislation, it is also a question of the enforcement mechanisms, because very often how rights are translated into real practice on the ground doesn't just stem from the legislation, it stems from ECJ judgments. So absent that pillar of those kind of judgments, we're not in the same situation, even if we have on paper an agreement to dynamic alignment.
Yeah, that's what I'm saying.
That's what you're saying.
Because I think there are sort of two issues here. One is a very difficult and rather sort of judgmental question about the extent to which UK courts, left to their own devices, they would be in these arrangements effectively, would adopt the same sort of, as Sarah put it, expansive approach to employment rights. That's an unknowable. We simply don't know. Yeah. But some writers in this area are a bit sceptical, some more positive. It's a bit unknowable. That's one set of issues. The other issue is that, of course, at the moment in the EU, effectively these rights have a sort of have a constitutional status. They are supreme. This is the supreme law above anything that domestic legislation can do. So they're a way of challenging domestic legislation. And outside the EU, given the UK constitutional position on the sovereignty of Parliament and the primacy of Acts of Parliament, it's very difficult to constitutionalise protection of workers' rights in the same way. There are sort of you can sort of half do it. You can the ideas of declaring that a particular piece of legislation has constitutional status, which means that the courts will be very reluctant to find that it's been impliedly repealed or altered by subsequent acts of Parliament. But that's as much as you can do. So it's very difficult to entrench anything. And if you compare that, say, to Ireland, where there is some constitutional protection of workers' rights in the Constitution, it's a different position. In analysis, it's very difficult to see how you can write something down which is entrenched.
If I can have one more, Mr. Chairman. I mean, my memory of this as a minister is quite old now because, as I said, I'm a Labour MP. But I do remember some of these judgments being quite important. For example, the ECJ, if memory serves me right, ruled on rolling up holiday pay while on maternity leave, which became quite important. That was an area of dispute, the extent to which women on maternity leave were entitled to holiday pay as part of their, and it was quite an important judgment on that. Going back to some of the earlier questioning about the various models of international agreements that have been mooted in terms of the future UK-EU relationship. Now, in this committee, we've been all around the world on this. I don't mean physically, but I mean in terms of the evidence we've taken. We've talked about association agreements, such as exist between the EU and Ukraine, customs union agreements, like with Turkey, free trade agreements, these best-in-class free trade agreements with Canada, Japan, South Korea. On the matter of labour law, do any of those models that currently exist come anywhere near the access to enforcement for workers' rights that exist at the moment? I'll start with you, Sarah.
The long answer is that there are other international labour standards. International Labour Organization has a series of conventions that countries across the world are signed up to. And I wouldn't denigrate that system at all. It's incredibly important. It sets really important standards. And I think we're all really pleased to sit in this room knowing that the clothes that we're wearing or the foods that we eat have been produced by workers who are protected by those standards. And International Labour Organization standards often feature in some of these other agreements that you've outlined. So it's in the Canada deal, for example, it says that the parties of that agreement agree to stick to the International Labour Organization standards. The problem is that they are not as well advanced and developed as the standards we have in the EU. CETA says it will respect International Labour Organization standards, but it doesn't come with any enforcement mechanism, and it doesn't come with any sanctions. So the short answer is no. Membership of the single market is a really, really unique beast, and it's one that workers here in the UK and across Europe are really pretty grateful for.
Thank you. Would anybody like to add in? That's my last question. So this is your...
Maybe just a small point that the current arrangements in the backstop, if the backstop ever enters into force, are not likely to be the only requirements in place, because these are only requirements in return for tariff-free access. It's very likely that if the backstop enters into force, that also market access will have been negotiated, at least to a certain degree, and it's very likely that the EU then will have requested more conditions in return for that market access. And then, of course, the question is to what extent can the UK negotiate the freedom to set its own labour standards or not? That's then, of course, another question. But I do think it's quite likely that on top of the requirements as part of tariff-free access, you will see other requirements as part of market access. Because if that market access will not have been negotiated, you will have a lot of disruption, of course.
Okay, I'll leave it.
Okay. Joanna Cherry.
Chair. Mr. Peretz, can I start with you, please, and go back and ask about the what you said about the implications for the devolved administrations of the UK taking control of its own state aid rules. And I'm thinking very much about the administrations in Edinburgh and Cardiff, not Northern Ireland, so obviously potential differences there. Earlier, I mean, you've written quite extensively about this, about the implications under the backstop and under what we know of the final relationship. And what I'd really like you to do is just take us through in a bit more detail what you were alluding to earlier, that there are implications here for the competences of the devolved parliaments, and what exactly are those?
Yeah, I mean, of course, the position at the moment is that the devolved parliaments act unlawfully if they pass measures that involve state aid. So that's, in that sense, the powers of the devolved parliaments won't have changed. It's just that the enforcement mechanism will be a UK enforcement mechanism rather than a rather than an EU one. And I think it's also important to say, just put it in context, so that the part of the justification for the state aid rules is one which I think there is some support for, certainly from the Welsh Assembly. I heard a speech last year by Carwyn Jones, who was then the First Minister of Wales, where he made the point in relation to the state aid rules that from the Welsh Government perspective they were very keen that they may be maintained, because he was concerned that without them that it was possible that different regions and nations of the UK may get involved in what are called subsidy races. And this is a real problem, and this is part of the reason why you have the state aid rules within the EU. It's to avoid the almost sort of farcical situation that you get in the United States, where different states within the United States start bidding vast amounts of money to get a particular company to locate within their state. And I remember last time I was in the United States hearing that Maryland, where I happened to be staying, had just offered £8 billion to Amazon simply to locate in their state. Now, it's that sort of completely ruinous competition that benefits nobody that's right at the heart of the justification of the state aid rules. And I think it's one of the reasons why, as a matter of policy, the UK government wants to maintain a state aid system. Of course, the current devolution arrangements were devised against the assumption that state aid rules would continue. So there's nothing in the devolution legislation that's designed to deal with this problem. If it was thought about, it was assumed that it would all be dealt with by the EU state aid regime. So it seems to me that as a matter of policy, there's every justification in terms of maintaining the proper relationship between the devolved administrations and avoiding completely ruinous subsidy races and other forms of harm, ways in which a decision of one devolved government can impact on the rest of the country. One wants to maintain the state aid rules. Now, in terms of the competences, there's a debate going on at the moment, which I've seen, as to whether state aid law is within is a devolved competence or not. I think there are sort of two views on that. It may have to be sorted out by the court, but although, of course, because of the Sewell Convention and the decision of the Supreme Court in Miller, it's in the end ultimately a political question anyway. If Westminster chooses to legislate on state aid, then it's a political issue. In terms of competences, it would certainly, and as I've written, as I said earlier, it is certainly right that under a domestic regime, whether the backstop or a regime devised in the light of a final relationship, or the government's proposed no-deal regime, there could be a situation in which the CMA, which will be part of the Crown, part of the UK government, could issue a decision that found that an act of the Scottish Parliament or of the Welsh Parliament was beyond its powers because it contravened the state aid rules by awarding aid that the CMA found was incompatible with the common market, on the UK internal market. So that's certainly right. That's certainly a possibility, and it would be a politically delicate position for the CMA to be in.
I mean, you've described the CMA. You've said that the CMA could be forgiven for seeing that task as a poison chalice.
Yeah.
I mean, you see there'd be quite major political implications if the Scottish Parliament passes a law and a UK-based agency is able to strike that law down. Do you see the political implications?
Absolutely. Well, that's precisely the thought that was in my mind when I wrote that sentence. I mean, one suggestion I've made, and it seems to me in the long term one might need to think about that, is that it might improve if we would to have a sort of internal regime as a long-run feature, that it might well be worth thinking about giving the devolved governments much more of a say in the appointment of the CMA than they
might be an option to
they currently
put
have.
The new agency in Edinburgh or Glasgow.
Unless of course Scotland became independent, in which case that might not be the appropriate place for it to be. But
if it become independent, we'll just be sticking with the EU rules. So
indeed,
sorry about that.
Of course, one of the reasons, and just sort of looking at the EU system, one of the reasons why the Commission is in a stronger position vis-à-vis any particular national government is that it's answerable, at the end of the day, to all of them. And it might be that the CMA might be in a slightly stronger position if it was able to say to any of the UK, Scotland, Welsh, Northern Ireland governments, actually we're the servants of you all and not just one of you. So that was a thought in my mind, but that suggestion
so really you're saying that the CMA might have a bit more might be seen as having more legitimacy in Cardiff and Edinburgh if it was seen as a servant of all the governments in the UK, not just the UK government, in the same way that the competition authorities in the European Union are servants of all the member states.
That seems to me a perfectly legitimate point of view. Ultimately, it's a political question, but I think there's a lot of force in that point.
I mean, what legal remedy would the Scottish Government, or indeed the Scottish Parliament, have if the CMA struck down an act of the Scottish Parliament?
It's not entirely clear what the right of appeal would be under the backstop. That's one of the things you will need to look at very carefully when the Withdrawal Agreement bill is published, as I hope it will be any day now. Under the no-deal instrument, which gives a clue to where the government is going, the remedy would be judicial review. And being that it would be a matter concerning Scotland, judicial review in the ordinary courts, so given that it was in Scotland, it would be judicial review in the outer house of the Court of Session.
But ultimately it would end up in the Supreme Court, wouldn't it?
If it was a question of law, yes. Yes, ultimately.
Does anybody else want to comment on this question? Keeping your heads below the parapet. I wonder if I could ask Sarah, just quickly, going back to Pat's questions. I think Pat's explored very effectively, if I may say so, what the loss of the Court of Justice of the European Union will mean for individual workers in the United Kingdom. But I wanted to ask you about what the British government have said they intend to do in order to protect workers' rights. And they made some proposals earlier this year, which they describe as their proposals for enhancing workers' rights once the UK leaves the EU. And in particular, they've talked about having a statement of compatibility with legislation. And I believe the TUC have raised some concerns and some critiques of what the UK government are proposing. Can you talk us through that?
Yeah, so what was proposed, I think, back in March, is that when the government introduces primary legislation, that would be amending employment or a health and safety right that was derived from EU law, then when it brings forward that legislation, at second reading, it would issue a statement of compatibility setting out whether the government believes that the new measure is a regression of rights or is fine in that sense. There are a number of problems with this. Obviously, a statement of compatibility, as anybody who knows the Human Rights Act statement of compatibility system can testify to, is not an objective statement. It is what the government wants people to think about a piece of legislation, and that would be the first problem. The second problem is that a huge number of changes that are made to employment rights aren't brought by primary legislation anyway, so it doesn't cover the whole range of mechanisms that would be used. There could no doubt be arguments around the edges as to which pieces of legislation, which rights actually require a statement to be made anyway. But in a sense, they're slightly technical concerns. Fundamentally, it relates to non-regression, but it isn't giving us that dynamic alignment that we want to go forward. It still doesn't account for all the other losses that Mr. McFadden was setting out in terms of enforcement. And again, this is something we've touched on in detail, but we do have concerns about protections for employment rights that are set out in domestic legislation, when at the moment we have an international system of protection. So a statement of compatibility system, in the current environment, even if it were passed by the members of Parliament sat in this room, might not survive very long under a new Parliament.
Can I just ask you all finally, clearly when we're talking about level playing fields, public procurement, the observation of rules in the field of public procurement is very important. Would any of you like to comment on to what extent, or whether to any extent, the saga of the no-deal ferry planning and seaborne freight has impacted upon the European Union's view of the British government's good faith in observing public procurement rules?
Its competence.
And its competence. Good faith and its competence.
a very large number of members of my chambers are involved in those disputes, as you can imagine. I mean, what the EU is making of them, I'm probably not the right person to ask, but Peter perhaps more. I mean, I think the overriding point is that the government has made it very clear that it wants to maintain the public procurement rules. They are well enforced in this country, and one conclusion one could draw from the saga is that when things go wrong here, and I think it's safe to say without any of my colleagues screaming at me that things went wrong in that case, or those cases, the courts exist and are very effective in sorting them out. And so Peter will say what the EU actually thinks, but I think one message one could draw from that is that actually the UK system for complying with its public procurement obligation, one could draw the conclusion that it actually has quite a robust mechanism, because when things go wrong, it is picked up and dealt with. That's one conclusion one could draw.
I mean, you've already indicated that for lawyers, that saga has been something of a dripping roast. There's a lot of litigation coming out of it. I mean, that's going to cost the public, the taxpayer in the United Kingdom, a lot of money, isn't it? Regardless of what eventually happens, it's going to be very costly what's happened in relation to the no-deal ferry planning.
When public procurement decisions go wrong, there are court challenges, then a large amount of public money is spent. That's certainly true.
So I think there's many examples, of course, also in the EU 27 in mainland Europe of mismanagement of public procurement. But what I can say is that I'm pretty sure that when we're talking about the future relationship, that the EU will insist on including public procurement, because this has been included in the EU-Canada deal, even to the extent that at the moment Canada has had to open up public procurement within its own provinces, which was apparently not already opened up as a result of the EU-Canada deal. So the EU sees this as a great success. So I'm pretty sure it will be included in the future, or the EU will try to include it in the future arrangement.
Dr. Lydgate, would you like to comment?
I'll pass.
Okay, thank you.
Okay, thank you very much indeed. Stephen Timms.
Thank you, Chair. I want to ask some questions about environmental regulation. Is there a model for dynamic alignment with EU standards on environmental regulation that we can see what it would entail?
I think that's a very good question. The EU has associated dynamic alignment with essentially the single market model, so the EEA, in which it forms part of very broad regulatory alignment. It's very intensive in terms of coordination with legislative changes in the EU. There are opt-outs, but they're used, essentially not used. So I think that sort of seems to be what the EU means by it. What Corbyn means by it, I mean, he's spoken about sort of maintaining the benefits of the single market, which suggests, broad alignment as well, but doesn't want free movement of labor. So that, to me, seems problematic in terms of securing EU buy-in. Of course, there would be the possibility for having a standalone agreement on dynamic alignment of environmental regulation between the UK and the EU. That would be very innovative. I don't think there are any existing models. I would ask questions like, would derogation be, be challengeable through arbitration? What kind of sanctions would there be? How would the sort of administration of it function? So I think we're looking at a sort of a lot of questions.
If you were asked to draft such an agreement, is it clear what would need to be in it? What it would look like? I mean, what it would need to cover, or is all of that at the moment unclear?
I think the starting point for it would have to be actually broad alignment with existing EU regulation. So you have to say, and we're specifically talking about environmental regulation, the starting point is that the UK would substantively incorporate the EU environmental acquis, because that gives a starting point from which you can begin to evaluate changes, and that I mean, in terms of models, again, we're looking at very closely integrated models, the EEA or some association agreement.
So that would imply, would it, that the UK would need to become a rule taker for EU environmental standards?
I think dynamic alignment does imply that the UK would need to become a rule taker, because first of all, I think it's very unlikely that the EU would agree to align to UK standards. And also because we would need to, in a sense, we would need to calibrate with the EU. So some would see that as a protective mechanism, that we would have built-in protection, but others might say, well, that would limit our ambitions.
Just picking up one of the points you touched on there, I mean, if you have dynamic alignment, then arguably you could say the EU ought to keep up with UK environmental regulation, and given that the UK has an ambition to be a world leader in addressing climate change, but from what you're saying, that there's no question that the EU would agree to such an arrangement, is there?
I don't think the EU would agree to such an arrangement with a third country. But I think another interesting point about dynamic alignment is that it differs from the model in the backstop, which doesn't actually require the UK to align to the substance of EU environmental regulations, but it does require that both parties maintain common standards in a wide variety of areas which are listed just as categories, which are almost comprehensive in terms of covering the EU environmental acquis. So, I mean, that's another model where you sort of say, well, we're not going to exactly, incorporate the entire substance of the regulation, but we're going to ensure that the level of protection is the same. I think it's worth noting that these common standards are tied to the end of the transition period, so this is a moving target. But again, in that instance, it's the EU who's sort of the default party setting the common standards rather than the UK. So I also think there's a lot of questions about, how do you evaluate, what is a common standard or a level of protection. I mean, if you think about environmental regulation, you have things like management plans for river basins and public participation requirements, and it's not just sort of quantitative emissions limits and things of that nature. So I would think that there would have to be quite a lot of work that would have to take place in terms of just drilling down and trying to identify, well, what is it? What are substantively the common standards, and what does it mean to lower them? I don't think it's at all self-evident.
Picking up points in the earlier discussion about labour market standards, I mean, do these matters frequently end up at the European Court of Justice?
Yeah, I mean, environmental non-compliance is a very frequent category of adjudication for the UK as well as many other member states.
So what are the implications of that for dynamic alignment, do you think?
So I think there's multiple sort of ways to address that question, but one of them is that is in terms of enforcement of dynamic alignment model, which is totally unknown. But I would imagine that, as I said before, because of the constraints that I think the EU would impose on the process, if we ended up with something like that in agreement, it would come with very broad regulatory alignment, and that would come with quite a strong role for the Court of Justice. But I think, go ahead.
So, sorry, so you're saying that any kind of conceivable dynamic alignment, the UK to the EU on environmental standards, would entail a big role for the ECJ in determining what happens in the UK?
I would imagine that the EU has its red lines as well as the UK. So, as I said before, I think the EU's understanding of dynamic alignment is that it's a feature of a very sort of single market model, and that it would come with very broad alignment. There could be a standalone environmental agreement on dynamic alignment, which seems like an interesting option, certainly, but would be quite innovative. There aren't sort of existing models out there. But if we're looking at the backstop and that sort of dispute settlement model, effectively that was a concession to the UK from the EU having independent arbitration. And I'd like to say for the record, because I think this is often misunderstood, that the environmental commitments in the backstop are actually enforceable. But they're only enforceable against the UK. And essentially how that works is that both parties agree to maintain these common standards, and that is Article 2, I think, of Annex 4, and that is not enforceable. But then there's Article 3, which says that the UK is obligated to effectively enforce its environmental standards, and that involves the public being able to initiate investigations. It involves having strong remedies and having an independent authority that can initiate investigations against government as well. So if the EU feels that the UK is not effectively enforcing its environmental regulation, then it can initiate a dispute through that arbitration process. So it is, it's another model for sort of making that actionable.
Can I just ask one final question on this? Is it true to say, do you think, that in the environmental area, the EU has kind of set the standard for worldwide regulation?
I think environmental regulation is a very complex picture. There are areas in which the EU is clearly, it's exporting regulation quite a lot. So for that reason, its regulation is globally important and influential. And it has.
Why do you think that's been? What has it been about the way the EU has set about this task that has made it so influential worldwide?
It's market power and market size is the short answer to that. But it's
not. You don't think it's because they've done a good job, particularly. It's just that they're big.
Well, I think in terms of why they have tried to export their model and been successful in doing that is due to market size. But they also do have quite a rigorous approach to certain regulatory processes. For example, the REACH regulation, the role of the precautionary principle is very strong, sort of consumer protection regulations, and so that is considered by many to be a gold standard.
Yeah. Okay, thank you.
I'd also add, just as a practicing lawyer, although I don't do much in the way of environmental law, one of the features of EU law is the remedies that it creates, so that you have a mechanism for NGOs, private citizens, to invoke environmental rights, take them to a court, get them adjudicated, get difficulties of interpretation sorted out by the European Court of Justice in Luxembourg, that has tended to take in very general terms, Emily will correct me if I'm wrong, but a generally pro-environmental interpretation of the legislation. And that's important in a context where there is always a temptation for governments and laws to enact wonderful sounding general principles, but then to be reluctant to apply those principles in the particular. And in those situations, it is rather important to the honouring of the general principles that there is a way of effectively challenging governments and parliaments saying, put it bluntly, saying one thing and doing another.
I would absolutely agree with that, and I think there are questions as to the UK's government's proposals to falling short in replacing these functions.
Now, Jeremy and I wanted to come in very quickly on this specific point, then I'm going to bring Vera Hoppers in. Jeremy.
Very, very interested in this, and the obviously EU has brought in extremely important environmental protections. But why was it that, for instance, with the Volkswagen scandal, that it took a US investigation to bring up what clearly must have been known to people within the EU and certainly within Volkswagen? I mean, I find that interesting. And would the UK have a similar ability to challenge the EU if a similar scandal arose in the future, let's say with things like antifreeze in wine, to quote another example in the past?
I think it's absolutely true that the EU is not stainless, and of course we're talking about 27 member states, and some of them have quite checkered records as well, and you can't monolithically say that, for example, the EU is ahead of the US. There's some areas where the US is more stringent in its environmental regulation, but I think that is, in a sense, a weakness of the backstop. Is that it's a unilateral scrutiny and monitoring process of the UK by the EU. The justification for that is that the EU has the Commission, it has the Court of Justice, who play a very strong role in monitoring and enforcing. They inspect member states, and they can take member states to court for not applying environmental law. That process can result in fines. So they have these mechanisms in place, whereas the UK is leaving it doesn't have these mechanisms. So that's sort of the Commission's, the EU's justification for that approach. But certainly, if we were moving on to the future relationship, we would hope that would be that dispute settlement mechanism would work both ways.
Okay. Vera.
It sort of leads quite neatly on about actually the proposed environmental protection mechanisms. So the question is again to you, Dr. Liedtke. The Environmental Audit Commission has described the proposals of the Office of Environmental Protection as being woefully inadequate. Do you agree?
I think for me, there are three main concerns with the Environment Bill. Just summarize very briefly. One is about the independence of the Office of Environmental Protection, which is meant to essentially scrutinize government, but much of its funding and appointments come from DEFRA, who it's supposed to be scrutinizing. A second point is about the role of environmental principles, which are now quite discretionary in their application, and the final one is about enforcement, because the OEP cannot initiate investigations, and in that sense, it actually arguably goes against what the UK has agreed in the backstop, which includes the EU obligated us to be for our body to initiate investigations. It's currently not able to do that, and it's even if it finds a serious failure to enforce environmental law, it can issue a report which is not enforceable. Sorry.
Could you actually describe in which way it would differ from the way the EU has the EU mechanisms work?
And on all three of those points, I think it's a weakening from the EU. So in terms of the independence, I mean, the Commission is a supranational body, so there's sort of independence is built into that. Mm-hmm. And in terms of the role of principles, those are set out in the EU founding treaties that environmental law in the EU shall be based on these principles. Whereas now ministers just have to have regard to them, and there are certain sort of opt-outs. And in terms of enforcement mechanisms, the Commission monitors. The Court of Justice has the ability to inflict penalties, including fines. Whereas in this model, there's a possibility for judicial review, but it's not. That's more limited in its scope, and it's not really clear how that would function because. The Office of Environmental Protection can't make binding rulings against the government anyway. So I think it does weaken on all these axes. And I think another point which has received less scrutiny, but which is equally important, is about the content of these statutory instruments that I mentioned in the beginning. So again, with the pesticides regulation, when we looked at it, we saw it actually removed all the checks and balances on ministers. So whereas in the EU regulation you have the Food Safety Authority, you have the Commission, you have a standing committee, you have individual member states all putting checks and balances into process of approving new active substances and pesticides, whereas in the UK statutory instrument, it's literally just ministers who have sole competencies for doing this. It also weakens the requirement for scientific independent scientific advice. So there are various sort of indications that we may be weakening the protections that we had under the EU.
And are you saying your main concern is about the independence of these bodies? But ultimately, we could look at our own legislation still and improve that, couldn't we?
Absolutely, yes. And I think, a best case scenario of this would be that the government is essentially, temporarily consolidating authority, until we know what our future relationship with the EU is, until we know what kind of regulatory structures we're going to have, because this is obviously a huge point of transition. But I think that the concern is that we're going from what's sometimes described as the legal lock of the EU, where the ministers couldn't change, say pesticides approval procedures unilaterally, even if they wanted to the opposite end of the spectrum, where we have this huge body of secondary legislation, which can be very easily reformed and amended in the future. As lawyers, we like to see things on paper. We like to have legal guarantees and legal protections rather than just hoping that there will be positive reforms.
Okay. Thank you.
Okay. Thank you, Stephen Kinnock.
Thank you very much, and thank you to our panel. I just wanted to unpack this notion that being a non-EU member of the European Economic Area makes a country a rule taker. I suppose the first point would be that most single market legislation is passed by qualified majority voting. So the United Kingdom as a member state doesn't have a veto on single market legislation, and therefore by definition is a rule taker if there's a piece of legislation that it's opposed to, but it's not able to form a blocking minority. As a non-EU member of the European Economic Area, the United Kingdom would have an independent voice on global standards bodies. So we would no longer be represented by the EU on those global standards bodies. And of course, as you've said, many of the EU's positions flow from those positions on global standards bodies. So there would be an influencing opportunity for the United Kingdom far greater than we currently have through membership of the European Union. Only about 30% of EU rules apply to non-EU members of the European Economic Area, because of course there's no common agricultural policy, no common fisheries policy, which generate vast amounts of legislation. There is no direct effect when you are in the EEA and not in the EU. The EFTA Court is not obliged to follow European Court of Justice decisions. New EEA law is only incorporated with the unanimous agreement of the EEA EFTA member states. Norway has obtained derogations from 55 legal acts up until June 2011, Iceland 349. These include the third energy package, third postal service directive, and the hygiene package, just to give some examples. And each country has a right of reservation, so new EEA legislation would have, if the United Kingdom were out of the EU but in the EEA, the British Parliament would have to pass all new EEA legislation based on debating and voting in the normal way in this Parliament. So, given all of that, would you agree that it's quite a lazy description of being EEA but not EU as a rule taker? Perhaps I could ask Mr. Klepper to comment on that.
Sure, thank you. This is, of course, these are arguments that you often hear. I don't think there's any doubt that there are some advantages in EFTA EEA in terms of sovereignty as compared to the EU. For example, the right to derogation. but then the right to the right of reservation. But the right to reservation is really only a right to delay. For example, Norway managed to delay the implementation of the postal liberalization directive, but ultimately it had to fold. The current NATO Secretary General, I'm sure you know his quote, Jens Stoltenberg, he has been saying when he was Prime Minister of Norway that his own country was a fax democracy. Now again, you're right that at the moment, if you're a member of the EU, there's already QMV, so there you don't have a veto. But what is very important in this is that as an EFTA EEA member state, one is obliged to take over 100% of the relevant legislation. Now it is true that many of the European Union rules are not relevant to countries like Iceland, Norway, and there's often a bit of haggling about the question, is this piece of legislation actually relevant or not? But fundamentally, if regulations are relevant, an EFTA EEA member state has to apply it. Also, what you often hear is that yes, but then if the UK would be in EFTA EEA, it would have more power to shape global standards, which is true. And those global standards often inspire EU regulations. But then I often respond with the argument that in Geneva you don't have 30,000 lobbyists. So apparently industry finds that ultimately where you need to be to shape legislation is in Brussels. It's not in Geneva or other places where you have these global standards. So I think ultimately, I personally, I may be wrong, but I don't see a country the size of the UK that this model would be a sustainable fit, perhaps as a transition. But ultimately, I think it would be very complicated.
Yes, maybe Sarah, yeah.
I was just going to say that I didn't say the rule taker comment, and it's not really how the TUC thinks about things, but it's clear that we live in a globalised world, and no country gets its own way on things at all, and there's strength in numbers. So the way we see it is essentially, whose gang do you want to be in? You've got Trump's America, you've got China, you've got the EU. In terms of, there can be different forms of relationship, but in terms of history, in terms of shared values, in terms of proximity, a close relationship with the EU, it seems to us, as one that's going to much better serve our country than one of those other sort of alliances.
Thank you. Mr. Perez.
Just a couple of points. I don't disagree with anything you said in sort of list of points about how the EEA agreement works. I think it's worth sort of just working out why there is a difference of view about this, where you get such different perspectives, and some people describing it as a rule taker and some people not. Part of the reason for that is simply that because at the moment the EEA 3 are two very small countries indeed and one quite small country, the large parts of the EEA agreement are simply not being tested. So there is an open question about how large parts of it would actually work with a very large member state as opposed to three very small ones. It's worth remembering that when the EEA was originally set up, it was designed not to deal with one quite small state and two very small states, but actually quite a large number of medium-sized states. It was envisaged that Sweden and Austria and Switzerland and Finland would all be in it. And for various reasons, they disappeared off in different directions, leaving just the three. And because of and three quite unusual economies as well, so the large areas of which those countries are simply not interested at all. So that needs to mean, when one looks at large parts of the EEA agreement and one asks sort of fundamental questions about what would happen if, the answer is we don't really know. It's never happened. So that's one point. The second point, I think, is that it's important when thinking about the EEA. In the end, it's going to be a comparative exercise, not an absolute one. You've got to measure that model against other models that may or may not be available. And in any regime where we're in level playing field territory, dynamic alignment, there will be the UK will be the smaller party vis-à-vis the EU. The EU is bigger, B has legal difficulties of its own in agreeing ever to be influenced by a third country because of the principle of autonomy of EU law. So any model of dynamic alignment, aligning to the single market, whatever that means, whatever one's thinking of, there will be a relationship where the UK is reacting to EU developments and under some form of obligation to follow, which may be qualified limited in various ways. And the question one has to ask is whether that model that one comes up with is better or worse than the EEA model. In the end, that's a political question, but that's the right question to ask, rather than is the EEA turn the UK into a rule taker?
I completely agree with that last point, because this isn't an absolutist debate, it's a relative debate. It's not this option is going to be the perfect world for everybody. It's much more about, compared to the other options, is this the one that most people could live with? And I specifically wanted to just follow that on the issue of jurisdiction and the role of the European Court of Justice vis-à-vis the EFTA Court. And obviously there is no direct effect in the EFTA countries. And given the legal expertise that we have on the panel as well, it'd be interesting to just unpack that a little bit more. Could you say a bit more about how you see the dynamics of the relationship between the European Court of Justice and the EFTA Court? And I know it's a bit difficult to do crystal ball gazing, but imagine for a moment that the United Kingdom were a member of the EFTA Court, but not a member state of the European Union. What effect do you think that might have on the relative relationship between the two jurisdictions? I don't know who's best. Is that maybe you again? Sorry, Mr. Perez. Yeah.
Well, I suppose the question about courts, and I bear in front of them, I suppose it falls to me. One feature of the UK being in the EEA arrangement would be that there would be a UK judge on the EFTA Court. It also deals with a problem that one hits in negotiating other forms of arrangement with the EU, which is the principle that the EU, when it comes to questions of EU law, as a matter almost as a EU constitutional law, the ECJ has to be the final arbiter. Now, the EFTA Court is a very sort of clever way through that, which has got the approval of the European Court of Justice as a mechanism, which allows another court to apply EU law, effectively EU law, EEA law, in parallel with the ECJ. So there are attractions to that mechanism, particularly if one's concerned that by an arrangement that leaves the UK subject to what might be characterised as a foreign court, one with no UK presence at all. If the EFTA Court had a UK judge on it, it would be an international court rather than a foreign court, really. There's also, because the EFTA Court hears many, many fewer cases than the ECJ and always sits on bank, all three of them sit, there would be a UK judge in every case, which is not the case in the ECJ, where there's a UK judge only in a minority of cases, because the ECJ hardly ever sits in a court of 28 for very obvious reasons. So one might argue that the UK influence might be maintained, even possibly increased, under an arrangement where it was playing a full part in the EFTA Court. I mean, I must be careful about this sort of thing, because it's anyway wrong in principle to assume that a UK judge will decide things in the interests of the UK. That's entirely wrong. Judges are very independent. It's very difficult to comment on particular judges because the ECJ and the EFTA Court deliver all their judgments collectively, so the fingerprints of an individual judge are never on the judgments. So one's indulging in a bit of guesswork here rather than anything else, and one must avoid stereotypes about what particular judges decide. But I think one could sort of broadly maintain the point, and it's a point of political comfort at least, that there would be a UK judge sitting on a court taking important decisions.
Thank you very much.
Okay.
Yeah, thank you.
Craig McKinley.
Dr. Lydgate, you're probably the most useful at this one. I'm very pleased to have you here with your sort of skills and experience. Just examining what we, Eurosceptics, shall I say, perceive as where we would like to be. The CETA type deal. It's been agreed by the EU for, it's got there. Best in class, all of those good things. Just looking at one major export of Canada, I know the EU has managed to not allow full access straight away, but it will over time, Canadian wheat, for instance. I mean, there must be a bundle of different pesticides, herbicides, all sorts of things go into the manufacture of wheat. Seed quality, soil quality. It's a complex thing. How on earth has the EU managed to get its head around workers' rights standards for those working agriculture, all of those different environmental rules, with all those things that go into the manufacture of wheat? It's managed to get its head around that. And might I assume it's because it's taken the very sensible view that this is an advanced economy, an enlightened economy, a highly litigious economy, and so has accepted that these international norms will apply and they're going to be fine for us. But we seem to be in a situation now where the EU is sort of telling us, you're right up to our standard on the day you leave, but suddenly we're not going to trust you. Whereas we're trusting Canada because it is one of these advanced normal economies. Is that sort of where we are with CETA? How has it got its head around workers' rights and allowing maternity leave, having your holiday pay? How has it accepted what Canada does as perfectly acceptable?
I think that's a good question. I mean, I think that actually we wouldn't be placed into a different category as Canada. Rather, we'd be placed in the same category. So, for example, with pesticides residues, the EU's approach is that certain pesticides are prohibited. You can't even have residues of them, and that entails, that Canadian exporters comply with those regulations, and that also entails border checks. So that is the kind of regime that would then be applied to the UK. So it's just that the UK, it's the imposition of border checks,
or the potential for.
Yes.
Whether they happen in reality is another thing.
Well, that would ascertain whether regulatory requirements had been met. But to take another agricultural example, from CETA, the beef quota was revised upwards. My understanding is that Canadian beef exporters aren't taking advantage of that quota because their supply chains are set up to integrate with the US. So it's not cost effective for them to comply with EU regulations. So it's not simply the sort of the market access element. It's also the fact that supply chains are regional and countries are set up to integrate with their local regulatory powerhouse, shall we say?
Just looking at these sort of triangulations between countries is a very interesting dynamic. You've got probably the best in class, even further than Canada. EU would be the New Zealand, Australia, where they're completely independent countries. They've got their own legislators, everything else, and yet they've accepted each other, tariff-free. Your standards are as good as our standards. How does that then interact? Because there must be some countries that New Zealand has got a free trade with that Australia doesn't. How do they sort of agree that if something's come through the back door from Fiji that New Zealand's got an agreement with, how does it then go over to Australia? Or are they just a little bit more enlightened and sensible on these things?
Well, your choice of words is quite leading, but it is true that...
My question's often asked, sorry.
My understanding is that you are correct, that New Zealand and Australia have been more relaxed than the EU in terms of having differentiated trade agreements that then allow goods to circulate freely once they enter the border of one country. Having said that, they do have quite a lot of integration. So coordination, integration of rules, which comes alongside that.
And just very, very quick one, if I may, for Mr. Perez. I'm a chartered tax advisor. I know you have some interest in VAT and all those sort of things. You've strayed into some sort of tax policy, how the backstop. I mean, there's one, to start with, one that always comes to mind. It's the Enterprise Investment Scheme. We had to get state aid rule agreement. I assume on the basis that a small widget maker might get an advantage over a large widget maker if they took advantage of the Enterprise Investment Scheme. It seemed to be the most minutiae control that the EU, we had to get clearance from the Commission to implement that. Are you saying that certainly in the backstop we'd be in exactly the same level of Commission agreement for some type of tax change?
Well, or CMA.
Or CMA, which
is
effectively acting as an agent on behalf of. You know, it's got I think use
utmost respect.
Utmost respect. Yeah. And the direction of travel that we see in the political declaration could see that type of tax policy alignment and asking Commission for just rights to do things could actually be a perpetual state of affairs under a future political declaration once that's translated into the future framework.
If you have an arrangement where we keep anything like the state aid rules, and again one sort of looks at Ukraine, Turkey, other sort of large European countries, although obviously very different in many ways, that they have accepted state aid rules. If you keep the state aid rules, then you keep some degree of scrutiny of tax measures. And it's important to keep that in perspective. I mean, as I explained when I was answering Mr. Wilson's question, state aid rules don't constrain general tax rates, so it'll be specific. The EIS is an example because it's designed to benefit particular types of company. Yeah. Although, in a way, that demonstrates that actually you can, provided you target your aid at, for example, small companies with the EIS scheme, new enterprises, it's relatively easy to get clearance, and in some cases they fall under exemptions anyway, so you don't even need to go to approach the Commission or, in the domestic regime, the CMA. Yes, I mean you're right that if you continue the state aid rule, there continue to be tax law implications of that.
If it wants to implement an EIS type arrangement, have to ask the Commission for approval?
No, it doesn't, and that's because it doesn't accept the state aid rules. So I was back to the question. It's a fundamental question.
WTO standard.
The WTO standard. I mean, there are circumstances where a tax break would be a breach of WTO rules, so there would be an issue, a state-to-state issue. And so it's not entirely free, but it's quite right. It doesn't accept the state aid rules. I mean, the question is, do any of us think the EU is likely to enter into the sort of relationship we want without requiring some form of state aid rules as a red line from their point of view? My own judgment is that right across the spectrum of agreements that are being talked about in this House, the answer to that question is yes, that would be a red line, and that includes a Canada-type agreement, or Canada plus, whatever that means. And the answer to why not Canada is we are not Canada. We are differently located. We're right in the heart of the EU, surrounded by it. We have an enormous existence.
So Switzerland, even more so.
Yes, but Switzerland, as I think Switzerland, quite right, doesn't accept the state aid rules. That, I think, is best regarded as a historical anomaly. And the EU's position on any future relations with Switzerland has been pretty clear. They want Switzerland to accept the state aid rules going forward. And new agreements with Switzerland, such as relating to air services, have brought in state aid rules. So the EU's line is very clear on that. And we want, as Emily alluded to, we want arrangements where there aren't regulatory checks on the borders. We want to have no issue about retaliatory tariffs. We want to have a number of things that Canada actually doesn't have. And if we want anything more than Canada, if the option chosen by the House and the government for a closer relationship with that, then even more so the state aid rules are going to be a quid pro quo. And from the point of view of an EU politician, that seems to be inevitable. You can't sell to your own domestic constituency an arrangement that opens the EU up to a very large volume of imports from a very closely neighbouring country, which is not bound by rules that you yourself are bound by. How are you, as a politician, justify that to your own electorate? That seems to me to be very difficult.
Well, I think that seems to be a very good answer in which to draw the session to a close, because members have asked all the questions they want to ask, and on behalf of us, can I thank all four of you for coming along here today. It has indeed proved to be an extremely interesting session and will be of great assistance to the committee in our work in the months, I could say years ahead, but who knows. Order, order. Oh, sorry, well, anyway, we've finished the session. Just to say, if there are any further observations that you want to make, that you'd like to submit to us in writing, once the Withdrawal Agreement Bill is published, then please feel free to do so.